actually in the presentation. But again, thanks for joining. Tonight we're going to talk about the very important topic of estate planning. So tonight we're going to cover several things. We're going to talk about what estate planning is. We're going to talk about all the documents that encompass a full and complete estate plan. And then we're going to talk about, well, what are the ramifications if we don't have this? If something happens to me, what are the ramifications to my family if I don't have these documents? So we'll cover all of that in about 15-20 minute presentation, and then we'll open up the floor for your questions. So if you have any questions, you can put it in the chat bar so you don't forget them, or we'll answer them later. But let me go ahead and share my screen so you can follow along with the presentation. And I love this first slide because I think this first slide pretty much tells you every reason of why we need to do our estate plan without saying a word, and that's family, right? We do our estate planning to make sure that everything that we have or whatever we acquire in the future, we want to make sure that when that day comes and we pass away, we want to make sure that our assets receive, or our beneficiaries receive all of our assets in the most time efficient way, in the most cost effective way. And that's what we do every day at NetLaw. We help families create their estate planning documents. And the key thing about these documents is they're all state specific. And what that means is the same documents you would get at an attorney's office, you can receive through the NetLaw software. So let's talk about what NetLaw is first. NetLaw is an IT company. We're a document creation company that was created out of a law firm called the Hargrove Firm in Louisville, Kentucky. The reason that our law firm created this sub-company NetLaw was because way back in 2012, we read in a Bloomberg report, and it said that 60% of Americans didn't have their will. Pretty close to what our poll said, right? So that concerned us, right? Why is it that 6 out of 10 people aren't coming in to do their estate plan? Even if you ask them, hey, do you have your will and trust? Most people will say no. But they always follow up with, I know I need to do that. I know I need to do that, right? But we still like to procrastinate on this. And this is one of the biggest things that we procrastinate on. And there's really two reasons why. One is cost, right? It is. It's expensive to come in, see one of our attorneys, and get your estate planning documents done. But the second reason that we found why people procrastinate, they don't think that they're wealthy enough. I'm not a multimillionaire. I don't own multiple houses. I'm not a business owner. So I don't need estate planning. That's just for the ultra wealthy. Nothing can be farther from the truth. If you own a house or a car or a bank account, you have it in an estate. And if you don't take care of it, your state will take care of it for you, and nobody wants any kind of government interference. That's why NetLaw is so important. So how did we create this software that helps you create your documents? From our law firm, we went out and we hired attorneys in all 50 states to come in and help us create the NetLaw software. And the reason that we did that is we wanted to make sure that you had state-specific documents. Same documents in our law firm is the same documents you're getting with our software. And when we created this software, we won the James Keene Award from the American Bar Association. This award is handed out each year to the company that has the best online delivery of legal documents. And still to this day, we are the only ones in estate planning to win this award. So I want to make sure that you have a full understanding of what you're using through a software has been recognized by the American Bar Association. Again, the best online delivery of legal documents. And these are all of the documents that you receive in our full premium probate avoidance package. And as you can see in the middle of the screen, includes free spouses plan. One plan covers both spouses with all of these documents. So let's run through these documents and talk about why each and every one of them is so important. And I always start with the will. To me, the will is the most important document. I always say your will is your listing document. And what I mean by that is we're going to list everything in our will that is important. And there's three things that we really focus on in our wills. One is executors. These are the people that you are going to name who's going to handle everything when you pass away. Their major responsibilities are making sure that all of our creditors are paid off, our taxes are filed, our assets are distributed to our beneficiaries. They're going to file our will with the county records department for us as well. They do a lot. Your executors do a lot. One of the biggest questions that I get is, can my executor be someone from overseas? Sure, they can. But not only do you name a main executor, but you name your successors or your backups. At least one of your successors has to be someone from your state. Most states mandate that because there's a lot of legwork that goes on. They're going to have to go to your house, maybe your place of business, maybe your financial institutions to grab all of these documents so that they can make sure that everything gets distributed. That's something that someone from overseas can't do. So making sure that we have everyone in place is why we have our guardian or our executors. Number two is guardians. If you have children under the age of 18, like the post said, most do. If something, God forbid, happens to mom and dad, who's going to take care of the kids? We need to make sure that we have people in place that will have custody of our kids. Yes, again, it can be someone from overseas, but again, very crucial that you have someone from your state named so that if anything does happen, they can go grab the kids right away. So they don't go to foster care or into the government system. And the last reason our will is so important, we call it specific bequest, but what that is simply listing all of our assets and naming those beneficiaries. Here's everything that I have, and here's who's receiving it. You can even put your international property into your will as well. Now, you still have to follow the law of the land over where your assets are, but at least you have them listed so your executor knows everything that you have. So everything gets distributed at one time and without anything being missed. So that's why it's so important to have our will. Executors, guardians, and specific bequests. Second line item is children's trust. This is for those parents that have underage children. Mom and dad pass away, the kids are still minors. When do you want your child to receive their inheritance that you leave behind for them? You have to at least wait till they're 18. If you do nothing, they will receive everything at age 18. And that sounds great, right? Mom and dad have passed away. Let's make sure the kids get everything right away. But let's remember they're 18. Maybe not the most maturest of individuals, right? With the children's trust, the parents can dictate when that child will receive their inheritance. So maybe they receive it all at 25 or all at 30. Or maybe you break it up into installments, some at 21, some at 25, some at 30. You can string it all the way out to age 35 if you want. Parents love this option because they receive a little bit of a time so they don't blow through it when they're young. Third line item is our durable financial power of attorney, naming someone who can handle our finances if we're incapacitated, we're sick, we're in the hospital. They can make sure that everything from a financial matter is taken care of. You can even use, and I've done this, financial power of attorney came in my life in a great way because I was in California doing a training for net law. And of course, when I was in California, and I live in Kentucky, so, almost 2/3 across the country. I was selling my house, and of course, they had an opening when I was in California. They said, if you can come in tomorrow, we can go ahead and close on your house. I had my power of attorney go and sign all of my paperwork. I was working, still got to buy my house. So important. I said in the beginning that this was a full comprehensive plan as well. Not only are we going to take care of your finances, but we're going to take care of your healthcare documents as well. Healthcare surrogate is your medical power of attorney. Who's speaking to the doctors and nurses on your behalf? And your HIPAA authorization grants access to all of your medical charts to your healthcare surrogate or any one of your choosing so that they can have that informed decision with the doctors. They are well aware of everything that is going on. And your advanced directives. End of life decisions. What do you want to happen at end of life? Do you want to be hooked up to a machine and kept alive? Or do you just want to pass naturally? There's several end of life questions that you will answer as well to keep you in full control of everything. We even have a pet trust. So if you're a pet lover, you can leave money behind to a person who is going to take ownership of your dog or your cat, so that it doesn't become a financial burden to them. And then the big one, the revocable living trust. And I'm glad 81% of people didn't have the trust, because I will tell you about 80% of every question that I deal with every day is about the trust. So let's talk about the trust. This is a revocable living trust that is probate avoidance only. This trust allows you to transfer your assets, your major assets, that do not have named beneficiaries. You can take these assets and transfer them out of your name and into the ownership of the trust. We're talking about major assets that do not have named beneficiaries, like your house or properties, cars, rental properties, investments, businesses. All of those do not have named beneficiaries. You can transfer those assets out of your individual name and into the ownership of the trust. Here's why you want to do that. Because if you pass away without having a trust, all of those assets are going to be frozen by the state that you reside in for a period of 6 months up to a year. The state comes in and freezes all of those assets. They do not get passed to your beneficiaries. The reason the state comes in and freezes those assets is because they want to make sure that all of your creditors get paid off. You owe them something, they need to be paid off. The state freezes your assets, makes the estate pay off all the creditors first, then the assets get transferred to your beneficiaries. But if you have this trust in place and you've taken those assets and transferred them out of your name and into the ownership of the trust, once you pass away, those assets get transferred to your beneficiaries right away. It's a probate avoidance trust. I can't tell you how important that is. All of these documents are important, but that trust absolutely makes sure that your beneficiaries receive everything that they're owed right away. And we even have a 7-day money back guarantee. If you try it out for any reason you don't like it, we'll give you your money back, as long as you haven't downloaded your documents. All of these documents for both spouses, our cost is $600. $600 for all of this. In our law firm, this starts at about $3,500. 1/6 of the cost, because you're not going into an attorney's office. You're using the software to create these documents in the convenience of your home for both you and your spouse. Not only do you get to create all of these documents, but anytime there's a life event or a reason that you need to log back into your account and change your documents, you can do so at any time. This is a software. Log back in, you can update your documents at any time. And here's the great kicker. Absolutely free. We do not have any subscription fees. No monthly fees, no yearly fees. You pay the one-time fee of the $600, and you have full free lifetime access to your account so you can protect your legacy at any time. Most companies charge about $10 to $30 a month. We don't charge anything. You're in full control of everything. So why is estate planning so important? Well, we talked about it, right? We talked about the reason that net law exists. We talked about all of the documents and why they're so important. And we even talked about the ability to go back in and change your documents at any time, free of charge. But the last 4 slides I'm going to show you, probably the most educational, because now we're going to talk about the ramifications. Life goes on, right? This webinar ends and we go on with our lives and we don't do this. But if something should happen and we don't have these documents in place, what happens to our family? And this isn't a scare tactic. Again, it's education. You need to know what's going to happen. And most people just assume that if I pass away, my spouse gets everything. Not here in the US. Not at all. So the only legal term that I'll use tonight is intestate. Intestate simply means that you passed away and you did not have a will. So the state that you reside in will come in and they will dictate how your assets are distributed and to whom. Government interference that no one wants. But having this will allows us to list all of our assets and who those beneficiaries are. So there is no confusion. Everything is laid out so that everything gets distributed according to your wishes. And speaking of government interference, if mom and dad both pass away before the children are 18 without a will, did you know a judge will dictate who gets custody of your kids? A judge. There's 45 of us on this meeting tonight. I guarantee all 45 of us probably think that having a judge make that decision, probably a bad idea. We know who's best to raise our kids. We know who we want to raise our kids. Leaving it up to a judge to make that same decision, sketchy. Having these people in place now is so important. Job number 1 of a parent, protect our kids at all costs. This is one of the ways that we do it. And we want to keep our beneficial or our executors out of probate court. If you fight the probate process, if you do not have a trust, it's very time consuming. Like I said, probate's going to last 6 months to a year. If you fight the probate process, you have to hire an attorney. You have to go to court, or the attorney goes to court for you. That's money that's being wasted on the court system instead of that money getting distributed to your family. Getting these assets to our beneficiaries right away is so important. Last slide, then we'll answer any questions that you have. Don't skip out on the medical documents. These are just as important as your financial documents. The one thing we don't want to happen is for you to be at end of life and your family's huddled up in the corner somewhere trying to determine what you would have wanted at the end of life because you never had that conversation. But we do all of these documents now, your financial and your medical. We do all of these documents now while you're young, healthy, in your right state of mind. So everything is in an orderly setup. This is what we do every day at NetLaw. We help families create their state-specific legal documents online in the convenience of your home. Just remember that when you create these documents or you edit your documents, you have to print them out and get them witnessed and notarized. And we have a great customer service area that can answer almost any question that you have. And you can always get with Anil. He can help you in any way as well. And if he can't answer that question, he has my direct phone number. He will call me. We will get, you're not alone in this. We will help you. So thank you for coming tonight. I hope you learned something. That's always my number 1 goal. I want everybody to walk away at least learning one new thing tonight. So Anil, let me turn it back over to you. And if there's any questions, we can go ahead and get those answered.
Thank you so much, Mark. That was very informative. Appreciate all the details that you shared. So just want to share with the audience that we as a financial advisors, share multiple different areas of defensive planning, and estate planning is substantially a big portion of that estate planning is of the defensive planning, and we want to make sure that people understand the importance of getting protected as much as they understand of the growth of the assets. And if you have kids, if you have assets, you do not want to go through the probate process. And one of the easiest way to avoid probate is having the probate avoidance package, right? Uh, Mark, I have a questions like one of the most common question that people ask is if they have a will, why they the trust?
Yeah, so the will does not protect against probate. The will is a public document. So the will is just there for you to list everything that you want to happen so it can be followed through with. The trust is what actually gets the assets transferred to your beneficiaries right away. So that's the major difference. If you want everything to go through probate and not get to your beneficiaries right away, you don't need a trust. But no one feels that way, right? We want everything to get to our beneficiaries in the quickest way possible. That's why the will and trust work so close together. One lets everybody know what's going to happen, and the trust allows it to happen right away.
Thank you, Mark. Another question is, what if they have kids over 18 years old?
Yeah. So
Do
any
they
kid
still
over,
need
yeah. So any child, well, any adult that is over the age of 18 needs their own plan. So if you have adult children, you cannot add them into they're not covered by your will and trust. They need their own will and trust because they're a legal adult. One plan covers husband and wife. So if you have 18, 19, 20-year-olds, they need their own plan. But remember, it's great because now they have their plans, and as they go through life, they have unlimited access for free. If they get married, have kids, buy a house, all of that, all they have to do is keep adding it in there. It's great.
Thank you, Mark. The next question is the properties. Often people ask for like, can I transfer my house, cars, other accounts to the trust, and how easily it can be transferred to the children after that?
Yeah, so it's real easy. even if your assets are in the trust, you're still the owner of the assets, right? Because you're the trustee of your account for as long as you're alive. So in the will, you're listing, when I pass away, this property is going to this child, no matter what. But the trust gets it to them right away. I think that was the question.
Thank you, Mark. The next question is, we have actually, it seems like it's been answered. Like, can I cover the non-USA assets in the US will and trust?
Yeah, absolutely. We want you to list everything so your executor knows all of the assets. Now, remember, all of the assets that are in a different country, you still have to follow the rules of that country. But at least you're listing everything so you know that asset exists.
Thank you, Mark. Mark, I have one more question, which often my own clients ask for that. If they are to work with me on the will and trust, how much of the personal information is shared with the advisor?
Well, it depends. It can be, if you're going to help them create all the documents, they're going to see everything. It could be that they don't see anything through their financial advisor. So it's as much or as little as you want them to see. If you need full help, I know Anil can do this. He can walk you through the software. He can guide you in every way that you need to do it. So, it's up to you how much you want to show your advisor or how little you want to. So it's totally up to you.
Thank you, Mark.
Yeah, I'll just say, I think what the question is, your advisor cannot log into your account. If you don't give them your username and password, your advisor cannot see anything.
Exactly. So in an essence, like we as an advisor will help them complete the documentations, but their assets are always protected, even from our eyes too.
Correct.
Which is like a great way to have a privacy for them. The next question is, the properties has the mortgage with the bank. How
Mhm.
how do you transfer to the trust?
Yeah, so the mortgage is going to stay in your individual name. We're not changing the mortgage at all. Mortgage stays in your individual name. What we're going to transfer is the deed. The deed shows the ownership of the house. So what you can do is you can go down to the county clerk's office, take the deed, take your certificate of trust. You can go to the county clerk's office and they can create you a new quick claim deed or warranty deed in the name of the trust. That's putting the property into the ownership of the trust. Now, I will tell you, call the county clerk's office before you go in case they need you to bring in the quick claim deed or the warranty deed. Some may want you to fill it all out, which is easy to do. It's just address and stuff like that. But call before you go, and then they can create a new quick claim deed in the name of the trust. That's how you do it. We have a funding instruction sheet that walks you through how to do all of this.
Thank you, Mark. The next question is, so do the clients can create documents for themselves, or there's another way? So I can say, like, we as an advisor, we will help you, walk you through the entire process, including along with the, other business partners who have invited our guests over here, can reach out to them or reach out to me to get their, package started and the documents being completed with the help of our financial advisors.
Yeah, yeah. And it's a really easy software to use. So it's not complicated. It doesn't speak in lawyer talk, right? It's very easy to understand.
I would say, like, I would share my personal experience, Mark. On an average, it takes about 45 minutes to an hour to
Right.
complete the entire probate avoidance package. That
Yeah.
includes the wills, joint trust, HIP authorizations, power of attorneys. Everything gets done within less than an hour. So, it's a great software. Uh, Next question is, how do I register my trust in New Jersey?
Well, you don't want to register your trust. Your trust is a private document. You're only going to register your will. Your will is a public document. That's what you want to register with the county, not your trust. That's what keeps everything out of probate, is not having it on file.
Thank you. Uh, Mark, the next question is, Anil, where are you located? So I'm located in New Jersey, but our partners who have invited you are located like in your neighborhood. So, reach out to them to get your will and trust started today. Just wanted to share with the audience, the one of the reason I recently experienced an event where a close friend of mine collapsed, 42 years old, collapsed, very healthy, no signs of any health issues, just suddenly had a heart failure. And we've been talking for some time for him to have complete like his will and trust, and I understand, like, thank God, like, he was able to recover, but with the stem cell, unfortunately, in this kind of situation, if something happens, the family is left with a lot of court process. It's a simple 1 hour process can avoid all this, stress or anxiety of the family. I just wanted to share this. For that very reason, we are going to be giving the special discounts to all our friends and family here at special discounts at $450 for this package, and we want you to get you started. I will be sharing the link shortly, that you can get it registered or reach out to the person who has invited you, so you can get the special link to get this package for $450, and we will help you get it completed, and we'll get going. So Mark, I have a couple of more questions in the queue. Should I be including my investment brokerage accounts in my trust, or will is enough?
Yeah, so it's up to you. You can. Now remember, usually your investment accounts like IRAs, stocks, all of that has named beneficiaries attached to it. That will avoid probate automatically. Life insurance, 401k, IRAs, stocks, all of that should have named beneficiaries attached to it. Those avoid probate automatically and they go right to your beneficiaries. Now, if you wanted to put them into your trust, so you have your successor trustees handling everything, you can do that. You would just, go back to your life insurance policy and change the owner of the account. But most people usually leave that out because it's going to transfer automatically anyway.
Thank you, Mark. Mark, next question. So if the client is to buy a package in New Jersey, and if they were to move to Florida or the states, can they move their package and get the new documents for that specific state?
Yeah, absolutely. You just log back into your account, go under that My Profile section, change your address, and the software will update to the new state's documents. Just go back and answer all the questions again and print out your documents and get them witnessed and notarized. That's all you have to do.
Thank you, Mark. And do they have to pay for the package again?
No, absolutely not. All edits are free.
Thank you, Mark. The next question in the queue is, do I understand this correctly? This is a self-sufficient platform software and the customer service will help with any questions. And is there no direct review from any professional legal attorney?
That's right. You're creating these documents through a software which has been created by attorneys. So the attorneys have already created the software. If you need customer service help, you can talk to me. You can talk to one of the representatives at NetLaw. But yeah, an attorney will not review these documents, but we work with these attorneys every day. So if there's a question that you have that we can't answer, then we can just get up, go ask the attorney and give you the answer. But remember, the software has already been created by attorneys to make sure that you're getting state-specific documents from the state that you reside in.
Thank you, Mark. The next question is something that I can take it. Who will be the financial advisor? So we are, we are the financial advisor. We are licensed from state of New Jersey. We are not an attorney to give you any legal advices, but we do help you, advise you on the NetLaw software, how to help you, walk you through this. And some of the basic questions we will help you. But we do not provide legal advice. But Mark, if you can chime in a little bit more.
Yeah, that would be great. Yeah, you can always rely on your financial advisor, right? Most 99.9% of them are not attorneys. But again, they have my direct number. So if you need any help, they can get a hold of me and we'll make sure that every answer that you have or any question that you have gets answered.
Thank you, Mark. Looks like we are the last of the two questions we have in the queue. Okay. So what happens to stepped up appreciation of your primary home if it's in the trust and not in your name? Maybe
yeah.
if you...
Yeah, usually nothing. Now remember, there's no inheritance tax if you're a U.S. citizen or a green card holder. There's no inheritance tax until you have assets over 26 million as a married couple. So even the step-up basis, if you're not at 26 million, there's no inheritance tax. Now, if you have assets over 26 million, congratulations, right? They'll gladly pay the taxes on that if you're giving them 26 million. But usually that doesn't affect people.
So that's amazing. Thank you so much for sharing that. So definitely, like if the assets are under 26 million, our software is a perfect place to start. And one of the last question is, how do I transfer primary residence to trust?
Yeah, simply taking the deed of your house and the certificate of trust that you create with us. You can go to the county clerk's office and they can create a new deed for you. But again, like I said earlier, make sure you call them before you go because each county office is different. They may need you to bring in the deed, the new quit claim deed or the new warranty deed. They may have you fill it out. They may need more documentation, but call them before you go and they'll tell you everything that you need to bring. And remember, we have a funding instruction sheet that walks you through everything that you need. Yeah, township would be fine too. It's wherever, when I tell people, it's wherever you usually go to get like your car tags and all that. That's where you need to go.
Thank you so much, Mark. Looks like you have answered so many questions. I appreciate our audience appreciated all the answers that you have given. hopefully, like, people will not procrastinate anymore and they will take action to get their will and trust completed as soon as possible, hopefully within this week. It is an important document. You don't want to leave your family hanging in there for procrastinating something. Okay, it looks like we have one last question. Can we have instruction sheets?
Well, there's instruction sheets for every document. So there's a My Files section inside your NetLaw client account that this is where all your documents are stored. For every document that is created, you have an instruction sheet that explains everything. So yes, you will have all of that.
Mark, this is a very common question that we receive. The next question in the queue. What if, looks like we are getting more questions now. What if one of is not a US citizen or a green card holder only? Do they still need will and trust?
Well, they can still do anyone can do their documents. So we want everyone to do this. It doesn't matter what your citizenship is, you can do these documents at any time.
So you're saying like if somebody is, on H1, it's important for them to have a, legal or health documents created over here,
Absolutely.
including
Absolutely.
the guardianship.
You never know what's going to happen. We need to be covered over here. Absolutely.
Thank you so much, Mark. The next question is, does package provides coverage for HIPAA authorization?
Yes.
I know you already spoke about it, but if you can answer.
Yeah, absolutely it does.
Thank you so much, Mark. So, this was like very informative. One of the reason I wanted to do this was bring the awareness. So, just like one of a friend of mine, like who has procrastinated and put his family in very close danger of going through the probate process just by avoiding this. So, I just want to thank you for your time. And I want to thank all our audience like to coming tonight and, taking this opportunity to learn about will and trust. And we are looking forward to help you. And, thank you so much, Mark. See you on the field.
Yes. Thanks everyone for joining.
Thank you. Good night, everyone.